Now in the US, we, as you probably know, have primarily dispersed shareholder companies. In addition, however, we do have companies with controlling shareholders, and to a large extent, the rules are the same for both. There's some differences, and there's certain transactions that are important more in one than in the other, but for the most part, the rules are similar, and I will bring out both the similarities and the differences as I speak. Okay, so what are independent directors? First, in the US, they're elected by all shareholders. That means that if we have a controlling shareholder, the controlling shareholder elects all directors. Minority shareholders have no right to elect their own directors. Now, corporations, individual companies can provide for that, but it's rare, and I'm actually not specifically aware that any do. So when we have a controlling shareholder, the controlling shareholder does elect even the independent directors. So what makes them independent? There's a definition that the stock exchanges have issued and that must be complied with. That definition, generally speaking, says that those directors have no current or recent employment with the company or other business relationship with the company. There are more details, but that captures the basic definition. In addition, they cannot have any other close relationships with the company or the company's affiliates. Those affiliates would include the parent corporation or an individual controlling shareholder. Now, as you can imagine, there's a lot of room in this definition for a lack of independence as a practical matter. The decision whether to consider a director as independent is a decision that's made by the existing or the other directors. So I'm reading a definition here. The definition is reasonable on paper. In practice, there's reason to believe that it's less than perfect. We also have a transaction-specific definition. And as I'll discuss, what this refers to is the situation in which independent directors are making decisions about specific transactions as they are required to do. In those situations, the court will evaluate after the fact whether a director is interested in the transaction. That is a court decision. It's based on all the facts and circumstances and can be much more penetrating or much more detailed than the general definition. So, what do independent directors do? When do they exercise the most power? In general, of course, they're always there. They're on the board. They oversee management generally. But there are two situations in which their influence is particularly strong, or where they play a particularly strong role, and in fact, a leading role. One of those situations is on committees of the board. For the last decade or so, the law has required that a board set up 4 committees. Those committees must be comprised 100% of independent directors. So what are those committees? The audit committee is one, the compensation committee, the nominating committee, and the governance committee. As I said, each of those committees has only independent directors as their members. I'm going to be talking, well, let me move on. I'm going to be talking primarily about 2 of them, but we'll get to that in a moment. The second setting in which independent directors are important is with respect to certain transactions. I mentioned this a moment ago. There are certain transactions where the law induces or the law provides good reason for the independent directors to take a major role. One of those transactions is when the company is sold. Another is where there is a related party transaction. And the third is where there is a freeze out of minority shareholders, by which I mean a situation in which the controlling shareholder or a majority shareholder buys all the shares of the minority shareholders. In those situations, again, the independent directors play a leading role. Okay, so now we're going to go back to each of those two situations where the independent directors play a leading role. The board committees will be first, and again, a board committee only has independent directors sitting on it. Here are 4 committees. I'm going to talk about 2 of them primarily, the audit committee and the governance committee, because I believe they have most relevance to the Chilean context. Before getting to those, I'll just mention to you the compensation committee, as the name implies, sets the compensation for the CEO. So as you can see, this is more important in a dispersed corporation setting than in a controlled corporation setting. The compensation committee also makes recommendations about compensation for other management officials. The nominating committee is responsible for nominating new members of the board, new independent directors, as current directors leave the board. But again, I think the most important committees for this context are the audit committee and the governance committee. Before I move on, I want to just mention one difference in the United States between a company with a controlling shareholder and a company without. In a company without a controlling with a controlling shareholder, the controlling shareholder is allowed to appoint one person to the audit committee, but he or she cannot vote. So, in effect, 100% of the audit committee is still independent. That is, the members who have a vote and can make a decision, but there is, in effect, an observer that can be sent by the controlling shareholder. So, the audit committee is very important in the financial reporting process. As you know, financial reporting is a process. It begins inside the company with individual accounts being set up. Those accounts are, numbers are put into them as the company does business. They become a first draft of financial statements, at which point an outside auditor becomes important. The outside auditor, the relationship of the outside auditor with the company is largely through the audit committee. The audit committee has a primary relationship with the outside auditor. Of course, the outside auditor communicates with the CFO and the CFO's staff, but there is a direct relationship with the audit committee. The audit committee hires and fires and sets the pay of the outside auditor. The audit committee has direct communication with the auditor. And the audit committee makes key accounting judgments. So the way that works is the auditor comes to the audit committee and says, in preparing these financial reports, there are 5 judgments that have to be made. For instance, revenue recognition, or expensing or capitalizing an expenditure. The audit committee makes those judgments. The audit committee must have the financial expertise to make those judgments. So they must be financial experts. So, as you can see, the audit committee is very important in preventing financial fraud, financial abuse, or even self-serving judgments by management in the case of a dispersed shareholder company or by a controlling shareholder. Second thing, the important thing that the audit committee does is the audit committee receives confidential complaints by employees. We use the term whistleblowing. I don't know if that translates well into Spanish, but whistleblowers communicate with the audit committee directly and confidentially. Let's turn now to the governance committee. The governance committee has an ongoing responsibility to evaluate the governance process. That includes the process within the board, and it includes the relationship and communication between the board and management. This, I think, is particularly important in a controlled corporation situation. If the controlling shareholder is not allowing the independent directors to do their work, or not allowing the board as a whole to do its work, the governance committee is in a position to recommend changes. Okay, now we'll move on to the second situation in which independent directors have leading roles. And these are in certain transactions. These differ somewhat between a dispersed shareholder company and a controlling shareholder company. So I'm going to describe these somewhat separately. In a dispersed shareholding company, the concern is with CEO self-dealing. The transactions where that could occur are when the CEO resists the sale of a company, or when the CEO wants to sell the company on terms that are not in the shareholders' interests. The second situation generally is one in which there are two or more opportunities to sell the company, which is to say two or more potential acquirers. There may be one that will keep the CEO on a continuing basis, perhaps for more compensation, and there may be one that will pay more per share. For that reason, there's a conflict of interest on the part of the CEO, and there's a danger that in that situation, the CEO will transfer wealth, in effect, from the shareholders to himself or herself. Finally, there are related party transactions in a dispersed shareholder corporation, but it's not very common, at least not in a large publicly held company. So the independent directors by law have a role to play in that situation, but it doesn't come up very often. So now we'll talk about the controlling shareholder company. The goal here, of course, is to prevent wealth transfer from the minority shareholders to the controlling shareholder. What transactions present that risk? Here, related party transactions are important. Freeze out of minority shareholders is also important. That is, if the controlling shareholder wants to buy the remaining shares of the minority. So what legal rules apply to these transactions? The rule of fiduciary duty, which is a common law rule that says that the CEO has a duty to the dispersed shareholders. All management have a duty to dispersed shareholders. In a controlling shareholder situation, the controlling shareholder has a fiduciary duty to the minority shareholders. Enforcement is through private lawsuits primarily. And in those private lawsuits, what the court will do is review the process by which the decision was made. A decision to sell the company, a decision to not sell the company, or to sell the company to acquirer A rather than acquirer B, or the decision to allow a related party transaction to occur. And what the court will focus on is whether the independent directors controlled the process, literally led the process and controlled the process. If the judge concludes that they did control the process, the judge will typically let the transaction stand without any significant review or evaluation. And again, by control the process, I mean keep the CEO out of the room, ideally from the very beginning, keep the controlling shareholder out of the room in the sense of the independent director's room, but rather have the controlling shareholder be a counterparty with whom the independent directors negotiate as though it's a third party. If the answer is no, that the independent directors did not control the transaction, then the judge will evaluate the transaction. So the law does not require the independent directors to do this. The law gives the company's management and its board a choice. They can delegate the job to the independent directors, or in effect, they can delegate the job to the judge, who will decide whether the transaction was fair to the minority or not. What will be the outcome of the lawsuit if the judge says that the transaction is unfair? One would be to stop the transaction. This would occur if the lawsuit is brought before the transaction is completed. In legal terms, we would say they would enjoin the transaction. The other possibility is to impose liability, monetary liability, on either the CEO or the majority shareholder, depending on the nature of the company and the nature of the transaction. Liability for independent directors is very rare. Independent directors are protected in a number of ways. The law itself does not impose liability on them very easily. They also have director and officer liability insurance, and they're allowed to be indemnified by the company unless they engage in wrongdoing themselves. So if one of you were considering being on the board of a US company, or putting yourself in a position of listing a company, having your company listed in the United States, and subject to some degree to US law, your risk of liability as an independent director is close to zero. Now, I want to add one more legal rule when we're talking about a freeze-out or the majority shareholder buying the minority shares. In that situation, what I've explained so far still applies. The independent directors must control the transaction if the judge is going to defer to them and let the transaction stand without evaluation. But in addition, the minority shareholders have to approve the transaction. If their shares are going to be bought, they have to be given a vote on the transaction. Otherwise, in which case the transaction would stand. Otherwise, the court again will evaluate the transaction, determine whether the price is fair or not. So the rule is similar. There's just an added element of a minority vote in addition to an independent director approval. So I just want to take one moment to say specifically how the independent directors actually perform this role or create a record for a judge to find that they have followed an appropriate process. Typically, they will set up a special committee to review the transaction. That committee the obligation is to represent the shareholders' interests. As I said a moment ago, the CEO is not allowed in the room. The controlling shareholder is on the other side of the transaction, so not allowed in the room. And the independent directors or the special committee will review the transaction and negotiate with either an acquirer, with the controlling shareholder, or whatever the appropriate counterparty is in light of the transaction. That committee can also hire its own lawyer and can hire its own advisors, including a financial advisor. If this is a freeze-out transaction and shareholder approval is required, full disclosure has to be provided to the shareholders. Otherwise, the judge will evaluate the transaction. So I just want to say again, these are not rules that require an independent director to do these things, or require a special committee to make these decisions, management and the board can decide for themselves. Do we want to follow this process, in which case pretty much avoid judicial review of our transaction, or at least avoid serious evaluation by a judge? Or do we want to let the judge evaluate the transaction after the fact? For instance, if a controlling shareholder wants to have the corporation buy an affiliated company at a price that the controlling shareholder sets, they can do that. But the court is going to evaluate the price. Okay, I want to just take a minute for a couple things. I'm almost finished my description here. But the question of maintaining the effectiveness of the board over time is important. There are two mechanisms by which we do this. One is the governance committee is responsible on an ongoing basis for reviewing its processes. So if the board becomes ineffective, the governance committee can make changes. Second, we have a process of board evaluation, where individual board members evaluate each other and evaluate the board as a whole. This is done on a confidential basis, but what I understand from directors who participate in this, and all boards do, they find it very effective. Transparency to shareholders, which I understand is somewhat of an issue here. We don't have very much transparency in the sense of transparency into the boardroom. The transparency we have are the annual reports and the quarterly reports that are issued by the company as required by the securities laws. So the minutes are not available to shareholders. Now, there are legal processes where shareholders can sue to obtain the records of the company, but in the normal course, the minutes, for example, are not given to the shareholders. Okay, so what I've described are a set of rules, a court practice in reviewing board decisions. Obviously, however, there's reason to be skeptical that these rules work perfectly. They don't work perfectly. They can't work perfectly. There's an unnatural allegiance on the part of independent directors to the CEO or to the controlling shareholder. People are people. They're friends with the CEO. They're CEOs of their own companies. They see things through the eyes of the CEO, or they potentially can see things through the eyes of the CEO. In a controlled corporation, they know the controlling shareholder. They may have other relationships with the controlling shareholder. Even if they're not financial, they may be friendships. So there is a natural allegiance. And independent directors are not subject to liability in any serious way unless they engage in true wrongdoing. So why does this work to the extent it works at all in the US? And I do believe it works. It doesn't work perfectly, but I think it works. I think one answer is there is a threat to reputation. There is press coverage of business decisions. Institutional investors are very aggressive and will work with the press to highlight problems going on with management, with the controlling shareholder, or with the lack of diligence by independent directors. So this is a real threat, and I think that it's been a threat for 10 or 20 years, maybe more than 20 years by now. We did have a situation, I don't know, 30 years ago, 40 years ago, where boards were very passive, but we've evolved out of that, so that I think not only is the threat to reputation real, but I think independent directors have, to a large extent, internalized their position and understand what their job is, understand who they work for, which is the shareholders or the minority shareholders. And to a large extent, I think it does work through this internalization psychologically of the role of independent directors. It's taken a long time. I think when I started teaching, which is in 1990, we were perhaps just entering that phase. It wasn't long ago that Boards were considered passive, but it has taken a while. So that's a description. As I said, I'm hoping that I have highlighted the elements of our system that will have some correspondence or contrast or comparison with what happens in Chile. And I look forward to hearing my co-panelists' remarks. Thank you very much.